The courtroom went silent the moment Clarence Beaumont walked in, not because he was loud, not because he was important, because he was wearing a janitor's uniform. Gray shirt, gray pants, a small bleach stain on the left sleeve, and he walked to the defendant's table like he belonged there. He did. He sat down, folded his hands on the table, and looked straight ahead. No lawyer beside him, no family in the gallery, just a 67-year-old man with white at his temples, and a posture that said he had stopped apologizing for taking up space a long time ago. The plaintiff's attorney, a man named Vincent Harlow, looked at Clarence the way you look at something that has wandered into the wrong room. He leaned over to his paralegal and said something quiet. They both smiled. That was the first mistake. Millbrook, Georgia sits 40 miles southeast of Atlanta, small enough that everyone knows the church you attend and the mistakes you've made. Large enough that you can disappear inside it if you're willing to stay quiet. The community pool closed in 2009. The diner on Pemberton Street still uses the same menu from 1987. There's a water tower painted the wrong shade of blue because the contractor skipped town with half the payment, and nobody has ever fixed it. This is where Clarence Beaumont has lived for the last 19 years. He rents a room from a widow named Mrs. Eugenia Poe, who charges him $400 a month, and leaves a plate of cornbread outside his door every day without explanation. He works the overnight shift at the Millbrook County Courthouse, mops the hallways, empties the bins, polishes the brass handles on the courtroom doors until you can see your reflection in them. He is invisible in the way that only certain people are allowed to be invisible in small southern towns. Old, black, quiet, wearing a uniform that signals to everyone around him that he is there to serve, not to be seen. If you passed him in the courthouse hallway at 2 in the morning, you wouldn't look twice. That is exactly what Vincent Harlow counted on. But Clarence Beaumont was not always invisible. 31 years ago, he was Clarence Beaumont, J.D., partner at Beaumont & Reeves, the only black-owned civil litigation firm in Fulton County. He had tried 47 cases, won 39. 2 of those wins were overturned on appeal. He appealed them back. He won both times. The Georgia Bar Association gave him a Lifetime Achievement Award in 1994. He was 40 years old. He wore the same Navy suit he'd bought the day he passed the bar, because his mother told him the suit that carried you into the fight should be the one that carries you out of it. He was known for one thing above everything else. He never raised his voice. Not once. Not in 31 years. He believed that the loudest argument in any room is the one spoken quietly while everyone else is shouting. His co-counsel used to say Clarence Beaumont could dismantle a witness with the same energy most people use to order coffee. Then came 2005. He was representing a whistleblower, a county records clerk named Addie Simmons, who had documented systematic bid rigging in the Millbrook Municipal Contracts Office. The case was tight. The evidence was clean. Clarence had 3 witnesses lined up and a paper trail that went 12 years back. 6 days before trial, the evidence room was accessed after hours. 3 file boxes disappeared. The security footage showed Clarence entering the building at 11:47 p.m. He had been home asleep. He could prove it. His neighbor had seen him. His phone showed no movement. His key card hadn't been used. None of it mattered. The bar complaint came the following Tuesday. Tampering with evidence. Obstruction. His key card, he was told, showed an access code that matched the missing files. The code had been cloned. He knew it. His investigator knew it. Nobody in a position to stop what was happening seemed to care. He was disbarred in March of 2006. He never found out who filed the complaint. He had his suspicions. The names of 3 county commissioners sat in a folder on his desk for years after, but suspicions are not evidence, and Clarence Beaumont had spent his entire career understanding the difference. He sold the firm. He sold the house. He spent 2 years trying to clear his name through channels that were not designed to help men like him clear their names. Then he stopped, not because he gave up, because he understood, in a way that only comes after years of fighting, that some wars require a different kind of patience. He moved to Millbrook. He took the janitorial job at the courthouse. He mopped the same hallways where he used to argue in front of judges who had shaken his hand at bar association dinners. He polished the brass handles on courtroom doors and said good morning to clerks who didn't know his name. He had his reasons for staying close. He always had his reasons. 19 years passed. His daughter, Simone, 29, a high school history teacher in Decatur, called him every Sunday evening. She had inherited his stillness and his mother's stubbornness, which made her both easy to talk to and impossible to argue with. She called him Daddy, and she had been calling him Daddy for years while watching him carry something she couldn't name and couldn't fix. She had started a civil rights case at her school the previous spring. A student, a 17-year-old named Marcus Webb, had been suspended for wearing a T-shirt that quoted Frederick Douglass. The school board's attorney was a man named Vincent Harlow. He had a reputation in Decatur for winning cases through procedural exhaustion. Delay, refile, delay again. Drain the other side until they settle for nothing. He had also, Simone discovered during her own research, been one of the 3 county commissioners' personal attorneys in 2005. She didn't tell her father right away. She didn't know if it was the gunman. Then, Harlow saw her last name on the filing. The next Monday, Simone was placed on administrative leave. Pending investigation, the school board cited a complaint about classroom conduct. No specifics given, no timeline provided. She called her father on a Tuesday, not Sunday. That was how he knew. He listened to the whole thing without interrupting. When she finished, he said, "I need you to send me everything you have, every document, every email, every filing. Daddy, you're not a lawyer anymore." "No, send it anyway." He spent 4 days reading. He sat at his small kitchen table with Mrs. Poe's cornbread going cold beside him and read everything his daughter had gathered, and then he pulled the files he had kept in a box under his bed for 19 years, and he started reading those too. On the 5th day, he called Simone. "I'm going to file a motion." "You can't file a motion. You're not. I'm going to file it pro se. On your behalf." There was a long silence. "Daddy, Harlow has 3 associates and a firm that's been practicing for 40 years. Clarence looked at the stack of files on his table. The box under his bed was open. He could see the folder with the 3 names on it. Still there, still waiting, still patient in the way. Only truth can be patient. "I know," he said. "Send me his billing records for the past 5 years if you can get them. And find out who the judge is." He showed up to the courthouse the next morning at 5:45 a.m., same as always. He mopped the floor outside courtroom 3B. He polished the brass handle. He emptied the bin beside the judge's clerk's desk. Then he went home, changed out of his uniform, and filed a 14-page pros motion on behalf of his daughter, citing First Amendment violation, retaliatory administrative action, and procedural misconduct in the original suspension. The clerk who received the filing looked at his name, then at his address, then back at his name. "You're Clarence Beaumont?" she said. "Yes, ma'am." "The Clarence Beaumont?" He smiled. "Just the one, I know." The hearing was set for 3 weeks out. Vincent Harlow found out the same day. He called the school board superintendent and said, "And these are the words 2 separate people in that office would later testify to. Don't worry. This is a janitor filing paperwork. It'll be dismissed before lunch." He had not done his research. That was the second mistake. He showed up to the hearing with 2 associates, a medical-looking leather portfolio, and a suit that cost more than Clarence's monthly rent. He did not acknowledge Clarence when he walked in. He set his papers on the plaintiff's table, spoke in a low voice to his associates, and smiled at the gallery the way men smile when they believe the outcome is already settled. Clarence sat at the defendant's table in a charcoal gray suit, the same one his mother had told him to keep. He had pressed it himself that morning. He placed 1 legal pad on the table, 1 pen, and a single manila folder. The judge was a woman named Honorable Patricia Osi-Mensah, 61 years old, 23 years on the bench. She had a reputation for having no patience for performance and considerable patience for the truth. She looked at Clarence when she entered, She looked at him the way someone looks at a face they almost recognize from somewhere they can't quite place. She sat. She reviewed the filings. She said, "Miss Beaumont, you're representing yourself?" "Yes, Your Honor. And you are the respondent's father?" "I am." She looked at his filing again, 14 pages, footnoted. Then she looked at Harlow's response, which was 19 pages. She set both down. "Mr. Harlow, you may open." Harlow stood. He was smooth, he was practiced. He had a voice designed for rooms like this, resonant, confident, the kind of voice that sounds like it has never been wrong about anything. He laid out the school board's position in 11 minutes. Simone had made statements in her classroom that constituted professional misconduct. The administrative leave was standard procedure. The complaint against her was filed by a parent. The timing, relative to the civil rights filing, was coincidental. He used the word coincidental 4 times. Clarence wrote it down each time on his legal pad. Harlow finished. He straightened his jacket. He glanced at Clarence with the particular expression of a man who is already thinking about lunch. "Your Honor, Clarence may respond?" "You may." He stood. He did not open the manila folder. He did not look at the legal pad. "Mr. Harlow stated that the complaint against my daughter was filed by a parent. Is the complainant's name in the school board's filing?" Harlow shifted. "It's been withheld to protect." "It's a public record in an administrative proceeding," Clarence said, still quietly. "Unless the school board has filed a motion to seal, which they have not, the complainant's name is a matter of public record. I'd like to request that it be produced." Judge O.C. Mensah looked at Harlow. Harlow said, "Your Honor, the complainant's privacy." "The motion to seal was not filed, Your Honor." Clarence said, "The name should be in their documentation." The judge looked at the school board's filing. She flipped to page 7. She read for a moment. Then she said, "Mr. Harlow, the complainant is listed here, a Mr. D. Harlow." "Any relation?" Harlow's pen stopped moving. "That's my brother-in-law," he said. "It's not relevant. Your brother-in-law filed a complaint against the teacher whose student is the subject of a civil rights case that you are opposing," Clarence said, "on the same day that your opposing counsel's last name appeared on that civil rights filing. Your Honor, I'd like to submit Exhibit A." He opened the manila folder. He slid a single document across the table to the clerk. It was a time-stamped email from the school board superintendent's office. He'd sent at 3:47 p.m. on the same afternoon Simone's name had appeared on the civil rights motion. The email subject line read, "Beaumont, need to move on this." The recipient was Vincent Harlow. Harlow stared at the document. "Where did you get that?" he said to Clarence. "Discovery," Clarence said. "You filed a request for all administrative correspondence related to my daughter's suspension. I filed a counter request for all correspondence related to the complaint. Your own discovery produced it." Harlow looked at his associates. One of them was already reaching for her phone under the table. Harlow stood straighter. He recovered quickly. He was very good at recovering. He said, "Your Honor, one email does not establish." "I'm not finished, Your Honor," Clarence said. Judge O.C. Mensah said, "Continue." He produced Exhibit B, a billing record from Harlow's firm, dating back 4 years, showing payments from Millbrook County Municipal Services. He produced Exhibit C, the minutes from a 2005 County Commissioners meeting, publicly available, showing Vincent Harlow listed as legal counsel present at the table the week before Clarence's evidence room was accessed. He produced Exhibit D, a copy of the bar complaint filed against Clarence in 2006, and a signed affidavit from the courthouse security contractor who had installed the original key card system, stating that the system in use in 2005 had a documented cloning vulnerability that was never disclosed publicly and was patched in 2007. He placed each document in front of the clerk. He never raised his voice. He never touched his legal pad. Harlow's lead associate was typing something on her phone with 2 thumbs. Harlow himself had gone the color of old drywall. "Your Honor," Clarence said, "I am not here today to relitigate my own disbarment. I am here because the attorney who currently represents the school board opposing my daughter's civil rights claim appears to have a documented conflict of interest, a pattern of using procedural pressure to suppress cases brought by this family, and a direct financial relationship with the municipality whose conduct my daughter's student had the courage to challenge. I am asking the court to grant an emergency injunction reinstating my daughter pending a full conflict of interest review, and to order the production of all unredacted communications between Mr. Harlow and the school board from the past 24 months. The courtroom was very quiet. Judge O.C. Mensah looked at the documents. She looked at Harlow. She looked at class. She said, "Mr. Harlow, I'm going to need you to show me why this conflict of interest claim should not result in your immediate disqualification from this matter." Harlow opened his mouth. Nothing came out. That was the third mistake. Or rather, it was the first time he had no move left to make. The injunction was granted that afternoon. Simone was reinstated the following morning. 3 days after the hearing, Harlow filed a motion to withdraw from the case, citing a scheduling conflict. The motion was accepted without comment. The school board settled Marcus Webb's suspension case 6 weeks later. Full reinstatement. A formal apology entered into the public record, and a new student conduct policy, reviewed by an independent civil rights committee. Clarence was not in the courtroom the day of the settlement. He was at the courthouse at 5:45 a.m., same as always, mopping the floor outside courtroom 3B. The clerk who had recognized his name the morning of his filing found him there. She stood in the hallway in her coat before her shift and said, "Mr. Beaumont, I read everything. I wanted you to know I'm sorry it took this long." He wrung out the mop. He nodded slowly. "It took exactly as long as it needed to," he said. "Thank you, miss." He went back to work. Simone drove down that Saturday morning. She brought her father a piece of sweet potato pie from the place on Jefferson Street that he liked, and they sat at his kitchen table in the good light that came through the kitchen window in the late morning. And they talked for 3 hours about nothing particularly important. Her students, a novel she was teaching, a leak in his ceiling that Mrs. Poe was refusing to acknowledge, whether the Braves had any real shot this year. She did not ask him how he had kept those files for 19 years without telling her. She did not ask why he had never mentioned that Vincent Harlow's name appeared in the notes from 2005. She did not ask how a man who had lost everything had walked into that courtroom with a single manila folder and taken apart a 40-year firm without raising his voice. She already knew the answer. She had known it since she was 8 years old, sitting in the back of her father's car after watching him argue a motion she didn't understand in a courthouse she found intimidating. She had asked him on the drive home, "Daddy, how do you stay so calm when they're all talking so loud?" He had driven another half block before answering, "Because the truth doesn't need volume, baby. It just needs time." The Georgia Bar Association's review board reopened Clarence's disbarment case 11 weeks after the hearing, prompted by the affidavit from the security contractor and a formal petition supported by 31 members of the Fulton County legal community, several of whom had known Clarence for decades and had been waiting for exactly this kind of opening. He did not attend the first 3 review sessions. He sent written responses. He was polite. He was precise. He did not ask for anything he could not document. The 4th session, he attended in person. He wore the charcoal suit. Again, he answered every question in full. When the review board chair asked him how he had maintained access to the original case files for 19 years, he said simply, "I kept them because I believed the truth would eventually be in a room where someone was ready to hear it. I just had to be ready to carry them until then." The reinstatement decision came on a Thursday morning. Simone called him before 7 a.m. to tell him. She had seen it in the Bar Association's online bulletin. "Daddy, it's done." He was quiet for a moment. "Okay," he said. "Okay? That's all you're going to say?" He looked at the box under his bed. He had already taken the folder out, the one with the 3 names on it. He had set it on the table beside Mrs. Poe's Sunday cornbread, which she had left without explanation, same as always. "I'm going to need a new suit," he said. Simone laughed. It was the kind of laugh that breaks something loose in the chest after a long time of holding too tight. "I'll buy you one," she said. "No, I'll buy it myself." He still mops the courthouse floor some mornings. Not because he has to. The custodial company has 2 other staff who cover his shift now. He goes because he likes the quiet of the building before it fills with people. He likes the smell of the floor cleaner and the particular sound his mop makes on the marble. He likes the way the brass handles catch the light when he's just finished with them. There is a framed photograph in the hallway outside courtroom 3B now. Millbrook County had it commissioned after the Bar Association's ruling became news locally, then regionally, then beyond. It shows Clarence Beaumont in 1994, holding the Georgia Bar Association's Lifetime Achievement Award, 30 years younger, the same posture, the same expression he wore in the courtroom the morning he slid 4 documents across a table and changed everything. He walks past it every morning. He rarely looks at it. What he looks at is courtroom 3B's brass handle. He checks his reflection every time, not out of vanity, out of habit. Because his mother told him once that if you can see yourself clearly, you know you've done the work. There is a young man in Millbrook, a first-year law student home for the summer named Calvin Reese, 22 years old, the first in his family to attend law school, who heard about Clarence and asked if he could sit down with him. He drove 40 minutes to do it. Showed up on a Saturday morning with a notebook and a pen and a nervousness about him that Clarence recognized immediately, because he had been that nervous himself once, in a different suit, carrying a different kind of hope. Clarence made coffee. He sat across from Calvin. He answered every question. He did not give speeches. He did not narrate his own story with the gravity men sometimes assume when they know they are being admired. He just answered the questions, calmly, one at a time, the way he had always done everything. At the end, Calvin said, "How do you not have more anger? After everything they took from you?" Clarence thought about it for a moment. He looked at the box under his bed, empty now. The files were in a filing cabinet Simone had bought him as a reinstatement gift. Organized, labeled, properly housed for the first time in 19 years. He said, "I had anger. I kept it in a folder and I filed it correctly, and when the time came, I submitted it as evidence. That's the only anger I've ever trusted." Calvin wrote that down. He wrote it at the top of the first page, underlined, and below it, without really knowing why, he wrote 3 words that Clarence had said, almost in passing near the beginning of their conversation. Words Calvin hadn't been sure he'd understood until the end. "The truth waits. There is something that stays with me about this story. Something I keep coming back to. It's not the courtroom moment, though that was extraordinary. It's not the reinstatement, though that mattered. It's the 19 years. 19 years of mopping floors in the building where you used to argue before judges. 19 years of carrying a box under your bed. 19 years of letting people call you the janitor and say good morning without knowing your name and not correcting them. Not out of defeat, out of patience, out of the kind of faith that doesn't announce itself, that just keeps showing up at 5:45 in the morning and doing the work, and trusting that the room where the truth is needed will eventually appear. Most people would have quit. Most people would have walked away from that building entirely. Who could blame them? Clarence Beaumont chose to stay. He stayed because he understood something I think we forget too easily. That being invisible isn't always defeat. Sometimes it's position. Sometimes you stay close to the thing you lost because you know, somewhere beneath the noise of everything that happened, that the story isn't finished yet. I want to hear from you. Drop a comment right now. Tell me about someone in your life who kept going when they had every reason to stop. Someone who carried something quietly for years. Someone the world wrote off who turned around and showed them all what patience really looks like. I read every single one. Share this with someone who needs to be reminded today that being overlooked is not the same as being finished, And if you haven't already, subscribe and hit the bell. This channel exists for the people nobody sees coming, the ones carrying truth in a folder under the bed, the ones who show up at 5:45 and do the work and wait for the right room. Next week I'm bringing you a story about a woman who lost her restaurant, her name, and everything she had built. And then, 18 years later, walked into the very place that took it from her. What happened inside that room will change the way you think about who gets to decide when something is over. Don't miss it.